Okay, Ms. Underwood, are you ready to proceed with Mr. Stribbling?
I have a couple questions, Your Honor. If you'd like to call the case.
Okay. This is file 25-22360-FH, People versus Stephen Joseph Stribbling.
Ron Underwood for Mr. Stribbling this morning, Your Honor.
Do we have a prosecutor appearing on Mr. Stribbling's case?
Yes, Isaac Sneed on behalf of the people. Good morning, Your Honor.
All right. Ms. Underwood, you indicated you had some questions.
Yeah, the offer from Mr. Sneed is a as charged, no subs to one count, Your Honor. The other count and the supplements being dismissed in this matter. I've talked to my client. We would ask the prosecutor if he would consider a no contest plea due to lack of memory, Your Honor.
I have no objection to a no contest plea.
All right, and that's to one count of assault of a prison employee.
Correct, count one.
Your Honor.
All right, let's see, Mr. Stribbling, will you raise your right hand, please?
Yes,
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Stephen Joseph Stribbling?
Yes, Your Honor.
Mr. Stribbling, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count one, assault of a prison employee?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $2,500 fine?
Yes, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's giving you?
Yes, sir.
Do you wish to explain or challenge? I'm sorry. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Yes,
Ms.
Your Honor.
Underwood? Is that also your understanding, Mr. Stribbling?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Stribbling, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about July 29, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault on a prison employee?
No contest.
Has anyone made any threats or promises to induce you to plead no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter that plea?
Yes, Your Honor.
I'm sorry, what was that?
Yes, I do understand.
Okay, thank you. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain inducing Mr. Stribbling to plead no contest?
No, Your Honor.
No, Your Honor.
Sir Stribbling, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of a plea or sentence agreement, or otherwise failing to comply with an order of court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead no contest today?
Yes, sir.
Ms. Underwood, would you like to establish the factual basis?
Yes, Your Honor. I'm reading from the Michigan Department of State Police police report dated July 30th, 2024. From the information, Mr. Stribbling was a inmate at the Gus Harrison facility in Madison Township, County of Lenawee, State of Michigan. Mr. Stribbling, prisoner Stribbling, was in the, I believe, State Police annex there, getting fingerprints taken. And reading from the police report, prisoner Stribbling turned his head toward C.O. Schwartz and spit, making contact with C.O. Schwartz's right upper thigh. And I believe that was, and I believe it's clear that was intentional and not consented to by corrections officer Schwartz, or yes, corrections officer Schwartz, who was a MDOC employee employed at Gus Harrison in the discharge of his duties. I believe the factual basis has been established.
Mr. Sneed, are the people satisfied with that as a factual basis?
I am, thank you.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
It
Ms.
has.
Underwood? All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Stribbling has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for October 9th at 8:15 a.m. Mr. Stribbling, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful in your answers.
Yes, sir.
Judge, we'll
Anything
need,
else we need to address?
we'll need an in-person rep for fingerprints.
Got it.
Okay. Does appear we need fingerprints in the file, so that will have to be an in-person sentencing, so we can get that done on the day of sentencing. All right, Mr. Stribbling, you can let the officers with you know that you're done with court for today.
Okay.
Okay, Mr. Noe, I have Mr. Maples here. Do you need a breakout session with him?
No, Judge, I was just typing a message to you. No, I don't need one. We are all set. I already met with him this weekend. We are ready on that one when you are.
All right, this is file 23-21397-FC, People versus Stephen Maples. We are here today for a pretrial conference, and we are proceeding today by video conference. First, to have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. Charles Noe on behalf of Mr. Maples.
All right, and so we have been waiting on a report from Mr. Maples' expert. Where do we stand with that?
Where we stand with that, Judge, is getting that coordinated has been quite the effort on my end, to tell you the truth, because as a result of my client being incarcerated, having to, scrap together funds from different sources of people that I'm able to get. I was ultimately able to get those funds together relatively recently and provide those to my expert witness. And he's reached out to me just in the last 24 hours, indicating he received those funds and can proceed further with his evaluation, including meeting with my client and hopefully in the next week. So what that means is I do not have a report from Ms. Arnold, and she certainly, if I'm going to be using that or using an expert, she's absolutely entitled to that, amongst other things. But ultimately, we do have a number of deadlines coming up. Jury instructions due in right around a month, little less than a month. Motion to eliminate deadlines coming up, and a number of different, most importantly, jury trial coming up at the end of October. I believe set for 1, 2, 3, 4 days at this point, I believe. October 21st through 24th, if I remember correctly. I've had a conversation with Ms. Arnold about this. I've been following up with her. We've been very good about communicating with each other, to be honest with you, about updating on this particular issue, particularly that as a result of me unable to get her that in the fashion that I would like to get that to her and that she's entitled to. It'd be impossible, I think, at this point for me to provide her to that to her in a timely fashion for me to be able to get that to her, forensic center experts, whoever needs to look at that for the people, to give their opinion on any report that I would provide to her. So long story short, Judge, where we're at right now is, as of right now, we are set for a number of things, most importantly, jury trial. At this point, I don't believe that that I am prepared to go to jury trial. I'm still prepared, waiting for a report, and Ms. Arnold is still waiting. Just as importantly, Ms. Arnold's waiting for that report from me too. So this is set for a pretrial. A final pretrial October 8th, which is obviously fine. We can keep that date. But I do believe that at this point, a trial date in late October would be very difficult to accommodate both Mr. Maples and the people. So at this point, I don't believe we'd be ready for trial on that date. I've spoken to my client. He's obviously the one most prejudiced by this. He's incarcerated. He told me he has no objection to this. And also Ms. Arnold, without speaking for her, at least I'll let her put that on the record. My understanding had no objection to this as well, although it's up to the court's purview. I would ask Ms. Arnold to also weigh in as well, please. Thank you.
Ms. Arnold?
Judge, unfortunately, I don't think we can keep those trial dates as much as I wanted to. I don't know if the court wants to set a pretrial in a month to see, wait for Mr. Noe's expert's report, or if we want to set new trial dates at this time. I just defer to the court on this.
All right, so I guess what I'd like to do is convert the final pretrial to a regular pretrial. We'll see where things stand with the defendant's expert's report at that time. And hopefully we'll be in a position to schedule trial dates on October 8th.
we'll be vacating the end of October trial date then, Judge?
Yes.
Okay, all right. All right, we already scheduled right now for a pre-trial on October 8th. Is that okay? Just keep that on as a pre-trial on that day?
Yeah, we'll just treat that as a normal pretrial.
Okay. So I don't think I have to do any sort of stiff or anything then at that point, do I?
No.
Unless you, okay, all right.
No, I think we're all set. So is there anything else we need to address with the case today?
No, thank you, Your Honor.
All right. Mr. Maples, you can let the officers with you know that you're done with court.
Thank you, Your Honor. I am. Sure.
Ms. Hanson-Grimes, are you ready to proceed with Ms. Cooper?
I am, Your Honor.
This is file 25-22162-FH People versus Megan Marie Cooper. We are here today for a pretrial conference in this case, proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Attorney Ashley Hanson-Grimes on behalf of Megan Cooper, who is seated to my right in the courtroom.
All right, and where do we stand with the case today, Ms. Hanson-Grimes?
So, Your Honor, we previously set this pretrial when we thought there would be additional motions filed regarding a possible remand. However, Ms. Arnold and I were able to work that out. We currently have count 3 going to be heard in district court as evident by our stipend order for this pretrial today on November 10th. At this point, we really can't do much between now and then, as count 3 is a part of this case and there hasn't been any offers made, or I am seeking some additional discovery just by way of phone records and through the audio portion of my discovery request to begin with. But those are things that Ms. Arnold's office can provide me between now and November as well. So I would ask that our next pretrial be after that November 10th date, or November 12th, I believe it is. I think I misspoke there. If Ms. Arnold has no objection, because at this point, until we resolve count 3, I think that the court can't do much on counts 1 and 2 at this point.
Okay, Ms. Arnold, anything to address from the people's side?
No, thank you, Your Honor.
Okay, so if your preliminary examination is November 12th, the next Wednesday would be November 19th.
And that will work with me, Your Honor, if it works with Ms. Arnold.
Yeah, that's fine.
Okay, so November 19th at 8:15 a.m. We will adjourn the pretrial to that date. Ms. Hanson-Grimes, can you do a stipulation in order for that adjournment?
Yes, I will, Your Honor. Thank you.
Is there anything else that we need to address today?
Not at this time.
No,
Okay.
thank you, Your Honor.
Thank you, then we'll
Judge,
see you
I
back
sent you in the
on.
chat.
So November 19th at 8:15 a.m.
Okay, I just didn't know if that chat pertained to us. That's why we waited.
Sorry.
Okay,
Thanks, Judge.
thank you, Your Honor.
Ms. Underwood, I believe I have Mr. Gana here. Do you need to speak to him?
Yes, Your Honor.
Well, can you hear me?
Okay, sir. Yes, I can. Are you Xavier Gana?
Yes.
Okay, I'm gonna put you in a breakout session with Ms. Underwood if you give me just a moment.
Okay.
Okay, the gentleman at the MDOC facility, you're Mr. Kensner? Are you
Yes,
Mr.
sir.
Kensner?
Yes, Your Honor.
Mr. Kensner, your attorney is not logged in yet. I will, as soon as your attorney gets here, I will get to your case, okay?
Yes, Your Honor.
Ms. Underwood, are you joining that breakout session with Mr. Gana?
Yes, I'm ready.
You've spoken to him?
Yes, Your Honor.
Okay. Okay, this is file 25-22241-FH, People versus Xavier Santiago Gana. We're here today for a pretrial conference in the case. We're proceeding today by video conference. First, going to have the attorneys place their appearances on the record.
Isaac Sneed for the people.
Rhonda Underwood for Mr. Gana this morning, Your Honor.
Okay, and where do we stand with Mr. Gana's case today?
Your Honor, the offer from the prosecutor on this file is as charged, no subs, with a no upfront jail provision, Your Honor, Killebrew. Mr. Gana wishes to accept that offer, and we believe the court is in possession both of a signed plea agreement, Your Honor, and a signed advice of rights.
Okay, I do have those documents, Mr. Sneed. Is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Mr. Gana, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Xavier Santiago Gana?
Yes.
Mr. Gana, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, assaulting, resisting, obstructing a police officer?
Yeah.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the courts. Is that
Yes, Your Honor.
Yes, Your Honor.
and is that also your understanding, Mr. Gana, other than as we've discussed it on the record here today?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Gana, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about April 18, 2025, in the city of Adrian, County of Illinois, State of Michigan, that you did commit the offense of assaulting, resisting, obstructing a police officer?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gana to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Gana, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, not as far as like how long it would be, or just that there would be no upfront jail.
Other than that agreement that there's no upfront jail, you haven't had any discussions about what the sentence would be. Is that fair?
No, Your Honor. Yes, that's fair.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. Gana, I
Yes.
take you back to April 18, 2025. Were you on East Siena Heights Drive and Elm Street in the
Yes.
city of Adrian, County of Lenawee, State of Michigan?
Yes.
And at that time, did you come into contact with law enforcement?
Yes.
You were on your bike,
Yes.
and the officer was in a fully marked police car,
Yes,
and the officer asked you to stop.
yes,
And would it be fair to say you kept going on your bike
yes,
and they chased after you?
yes,
And then you ran from them on foot,
yes,
and you knew they wanted to speak with you.
yes.
I believe I've established the factual basis, Your Honor.
Mr. Sneed, are the people satisfied with the factual basis?
Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor, thank you.
Ms.
It
Underwood?
has.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Gana has had full knowledge of his rights, has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for October 10th at 8:15 a.m. Mr. Gana, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
All right, I'm going to put you in a breakout session with Ms. Teskey from the probation office so she can collect some.
Okay.
Your Honor, should we ascertain whether Mr. Gana wants his sentencing in person or via Zoom?
Sir Gana, you have a right to be sentenced in a felony case to be present in person for the sentencing hearing. If you would prefer to do it by Zoom, you're welcome to do that, but you would need to waive your right to be here in person.
Okay.
Do you know what you'd like to do right now?
Because of work and everything, I would probably rather just do it by Zoom. It makes it way easier.
Okay, you're willing to waive your right to be in person?
Yes.
Okay. So we'll do the sentencing by Zoom, and so I'll put you in that breakout session with Ms. Teskey right now.
Okay, thank you.
Ms. Underwood, Ms. Page is here in person in the courtroom. Do you need to speak to her?
Yes, please, Your Honor.
All right, Ms. Page, if you'll step out to there's an iPad just outside the door. I will put you in a breakout session with Ms. Underwood. I'm going to send you a request to unmute. Okay, 1 second. Okay, Mr. Malaro, you are handling Jonathan Kensner's case for Mr. Glazer, I understand.
Yes, Your Honor, I am Mr. Glazer today, although I don't look as good as he does.
Okay, do you need a breakout session with Mr. Kensner?
Yes.
Okay.
Thank you, Judge.
Okay, Mr. Gana, you're all set. You can go ahead and leave the meeting. And Mr. Brandt, I don't think I see Ms. Bersiaga logged in. Do you know where she is today?
Your Honor, I don't. Normally, I would have called her over the weekend. She's been here for all the other pre-trials we've had. I am headed to East Lansing, but I will try to reach out to her today. I would tell the court that Ms. Arnold and I exchanged emails about a plea framework. I think we have that, but we'd like to talk to the court about a Cobb's once we have sentencing guidelines done, and then I think this case is resolved.
All right, let me call it real quick then. So this is file 25-22115-FH, People versus Cabrina Leanne Bersiaga. We are here today for a pretrial conference. We're proceeding by video conference. First, going to have the attorneys place their appearance on record, beginning with Ms. Arnold.
Allison Arnold for the people.
Alfred Brand on behalf of the defendant.
All right, and so Ms. Arnold, Mr. Brandt was telling me off record, you've had some conversations about a potential plea agreement or offer that that is moving in a positive direction, I guess I'll say. Is there anything, I presume you heard what Mr. Brandt had to say. Is there anything you'd like to say in regard to that?
No, Your Honor.
All right. I do have a concern that Ms. Bersiaga hasn't appeared here today.
Judge, I think maybe if we,
yeah, go ahead.
I don't know if the court wants to set it for a Cobb's evaluation and have her zoom in at that time or set it for a pretrial in a week or so. She's always appeared, so I think it's probably just a lack of notice issue. So we're not asking for a bench warrant at this time, but I do think Mr. Brandt's going to need to speak with her because there are certain representations that I need her to make in the plea agreement that he's going to need to discuss with her.
Okay. I would agree. She has appeared at numerous other pretrial conferences without incident. And so what I will do, my next 2 weeks are pretty booked up. So I can do a pretrial on September 24th at 8:15. And perhaps in the meantime, Mr. Brandt and Ms. Arnold can contact Francis and you can set up a time to do a Cobb's conference.
So September 24th at 8:15, Your Honor?
Correct, if that date works for everybody.
I will prepare the stip in order, and yes, I will make sure my client is there. And then Ms. Arnold and I just contact your staff for, do you want to try and do the Cobb's evaluation that day or do it before, Your Honor?
I would prefer to do it beforehand. Wednesday mornings are tough for me to do those.
Very good.
Okay, so I think we're all set on that case then.
Thank you, Your Honor.
Thanks, Judge.
Thank you. Would you? Okay, Ms. Underwood, are you ready to proceed with Ms. Page?
I am, Your Honor.
This is file 23-21372-FH People versus Amber Elaine Page. We are here today for a probation violation, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. Page this morning, Your Honor.
All right, Ms. Underwood, where do we stand with Ms. Page's case today?
I believe Ms. Page, first of all, Your Honor, there is a lot positive going on with Ms. Page. I believe, but I'll get to that, but I believe she's going to enter a plea of guilty to the violation, Your Honor.
All right, Ms. Page, would you raise your hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalty for perjury?
I do, Your Honor.
And you are Amber Elaine Page?
Yes.
Ms. Page, do you understand that you have a right to contest the violation of probation charges and to have a trial on it?
I understand.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
I understand.
You have a right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses you have for your defense to appear at trial. You understand that?
I understand.
You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. You understand that? On the other hand, you also have the right to testify if you wanted to testify. You understand that as well?
Yes.
How do you plead to the charge that you violated probation by failing to attend treatment as instructed in July 2025?
Guilty.
And how do you plead to the charge that you violated your probation by being positive in admitting use of methamphetamine on August 10, 2025?
Guilty.
And how do you plead to the charge that you violated state law by being in possession of methamphetamine?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial already explained to you?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty today?
No.
Has anybody threatened you in any way in order to get you to plead guilty today?
No.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I understand.
Is it your own choice to plead guilty?
Yes, Your Honor.
So you were placed on probation in this case back in August of 2024, is that correct?
Yes, Your Honor.
And one of the conditions of your probation was that you participate in any treatment that was recommended or required by your probation officer. Is that also correct?
Yes, Your Honor.
And did Ms. Walsh recommend or refer you to treatment in July 2025?
Yes, Your Honor.
And did you fail or refuse to attend or participate in that treatment?
Yes, Your Honor.
On August 11, 2025, I'm sorry. Yeah, did you take a drug test on that day?
Yes, I did.
Did you test positive for methamphetamine on that day?
Yes, I did.
Had you used methamphetamine the day before on August 10, 2025?
Yes, Your Honor.
All right. I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Ms. Page has had full knowledge of her rights. She's had competent counsel. I will refer the matter to the probation department for an update of your pre-sentence investigation. And we can set sentencing for October 2nd at 8:15 a.m.
Your Honor, we're trying to avoid the first couple weeks of October just in case the budget isn't figured out and we are shut down at that time. Can we move it out a couple of weeks just to be safe in case the government doesn't figure out what they're doing?
Okay, we can go to October 16th.
Yes, thank you, Judge.
You know, Your Honor, if I could just briefly say, according to Mr. Coast, Ms. Page has had clean drug tests the last 4 tests. She's back with Catholic Charities. Also, and maybe more important for Ms. Brenner's purposes, it's my understanding, I just spoke to, I believe it's Mr. Shepard, who is the payee on this case, who is, I believe, going to go down to the front of the court and make some major changes as far as perhaps forgiving an amount, because they are together.
No, I wasn't aware of that, Your Honor, but I am aware that she's still not meeting her monthly child support obligation. She's lucky that she hasn't been violated for that yet. Hopefully she can get her drug use checked and then start providing for her child so that she doesn't look at a violation on that front.
Thank you, Ms. Brennan. And this, I anticipate that there may be a change in the amount.
Right. Well, we will be informed of that when we get to our sentencing date. Obviously, Ms. Waltz will have an opportunity to update the court on any changes that are made between now and then.
Thank you, Your Honor.
So Ms. Page, your next date is October, let's say the 19th. 16th. October 16th at 8:15 a.m. Okay, so you're all set for today. Thank you.
All right, thank you so much.
All right, Ms. Underwood, you need to speak to Mr. Dennis.
Here, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, give me 1 second. My computer's acting a little funny. And Mr. Malaro, are you ready to proceed with Mr. Kensner?
I am, Your Honor.
Okay, so this is file 25-22364-FH, People versus Jonathan Tucker Kensner. We are here today for a pretrial conference in the case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Salvatore Malero on behalf of Mr. Kensner, covering for John Glazer.
Okay, Mr. Dennis, there should be something on your screen asking you to join a breakout session. Click accept or join or whatever it's asking you to do.
Nothing yet. Don't see. I don't see nothing yet, sir.
Hold tight, we'll send someone to your Zoom pod to help you.
Thank you.
All right, I apologize. Mr. Malero, where do we stand with Mr. Kensner's case today?
Your Honor, looking at the file and talking to Mr. Kensner, appears there is a co-defendant in the case. I looked it up. It says it's set for a pretrial on October 1st. So we'd ask to adjourn this to that date.
Okay, Ms. Arnold, is there anything we need to address from the people's side today?
The only thing is I'm not here October 1st, so I'm not sure how meaningful that pretrial is going to be, but we can set it for that date.
Well,
I mean, it might make sense to go to the following week or the week
so
before.
Mr. Kensner did mention October 20th, but I looked it up in my court and it says the 1st, so. But
It is, yeah.
So 20th, I think the 20th would be fine or whatever.
Well,
Okay, so why don't we do this? Let's set it for October 8th, and then Ms. Arnold, if you can get in contact with whoever the attorney is on the co-defendant's case, just do a stip in order to adjourn that one to the 8th too, so that we can have them on the same day.
okay, that sounds good, Judge.
So October 8th then, Judge?
Correct.
Okay. And
October 8th.
Mrs. Arnold's gonna do the stip on this one?
Not this one. I'll do it on the other one.
Sure.
You may sign my name though.
All right, we'll do the stip then, Judge. We'll step up.
Okay. All right, so Mr. Kensner, your next date will be October 8th at 8:15.
Okay, Your Honor, October 8th at 8:15. Sounds good.
And you are all set for today.
Okay, yes, Your Honor. You have a great day.
Thank you.
Thanks, Judge.
Thank you, Your Honor.
Okay, and so can you call jail for Matthew? Okay, and Mr. Miller, you also have Mr. Garrow for Mr. Glazer also.
Yes, Judge.
And do you need to speak to Mr. Garrow?
Probably.
Okay, Mr. Garrow, if you'll step outside the door, there's an iPad out there, and I'll put you in a breakout session with Mr. Miller.
Thank you, Judge.
Okay, Mr. Garrow, I'm going to send you a request to unmute that device, and then I'll put you in a breakout session. Need to unmute the device. There you go. Okay, Ms. Underwood, are you ready to proceed with Mr. Dennis?
Yes, thank you, Your Honor.
This is file 23-21255-FH People versus Brian Matthew Dennis. We are here today for a hearing on a probation violation, and we're proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Dennis this morning, Your Honor. Thank you.
All right, and where do we stand with Mr. Dennis's case today?
Your Honor, unfortunately, there has been no paperwork filed on the underlying OWI that is the result of this, that is the genesis of this violation. I've called the prosecutor's office. I've talked to Mr. Jones. Nothing has been done. Mr. Dennis has been given a PR bond on that, Your Honor. I obviously can't make a plea on my VOP with that out there. What I'm going to request, Your Honor, is that the court continue Mr. Dennis's not guilty plea and address the issue of bond, Your Honor. Mr. Dennis is a journeyman mason. He has his job. He also has a place to live with an address. I believe with appropriate testing conditions, perhaps monitored by Mr. Coast in this respect, Your Honor, that Mr. Dennis, because the state police need to be the ones taking their time, Your Honor, that Mr. Dennis be given a PR bond and allowed to address this issue when the issue of the OWI is addressed, Your Honor.
All right, Mr. Jones, is there anything you'd like to add with respect to the bond issue?
Judge, I'm with Ms. Underwood. I tried to contacted the prosecutor yesterday. They said they haven't received anything from the state police yet. I guess only concern would be the level that he was at on the alleged new crime. That's definitely concerning. Almost twice the limit. And he does have a history of drinking. I did receive a correspondence from him too, asking for help. And I think that's normal in this situation. People get caught and then they all of a sudden want help. So I guess obviously it's the court's decision on the bond issue, but if we can wait one more week and see if we get something, or if the court wants to put some limitations on him. I know he works. He does well on supervision when he comes to the office, but obviously outside of it, there's another issue with his drinking. I guess that would be concerning with the level and if he gets in the car and drives.
Your Honor, I would simply say that I think with testing and reporting to Mr. Jones and Mr. Coast, Mr. Dennis would be supervised very well. And I do think that even another week, Your Honor, this has been going on at least a week, I think. So they've had their opportunity.
All right, I am in agreement with Ms. Underwood that I think we can put together some conditions of PR bond that would address the concern about drinking. So I will grant a PR bond at this point to Mr. Dennis. Mr. Dennis, you must make reports to both your probation officer, because you're still on probation, but also to Darren Coast and Lenawee Circuit Court Pretrial Services. You must not use alcohol, marijuana, or any illegal controlled substance. You must participate in a alcohol and substance abuse testing or monitoring program.
Yes, Your Honor.
You must participate in any treatment programs that either Mr. Jones or Mr. Coast refers to you. So if they refer you to AA or Catholic Charities or whatever it is, you have to do that.
I'll do whatever it takes, Your Honor.
Also going to impose a curfew from 8 p.m. until what time do you get up to go to work?
Usually I'm up by 4:30 a.m., Your Honor.
What time do you leave the house?
Depending on where they have me working, I usually get up, give myself about 45 minutes to get myself around and hit the road. So I leave the house sometimes before 5, sometimes after 5. So.
All right, so we'll do a curfew from 8 p.m. to 4:30 a.m.
Okay. Thank you.
So when you're released, Mr. Dennis, you can come directly over to the courthouse and speak to Mr. Coast.
Perfect. Thank you very much, Your Honor.
What is our new date on this, Your Honor?
So with October 1st at 8:15.
Thank you.
Okay, I think we are all set then. Mr. Dennis, you can let the officer with you know that you're done with work.
Thank you, Your Honor.
Mr. Malero, are you ready to proceed with Mr. Garrow?
Yes, Judge.
Okay, this is file 25-22330-FH and 25-22331-FH. People versus Richard James Garrow Jr. We are here today for a pretrial conference in both of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Richard Garrow, substituting in for John Glazer.
All right, we also have a pending show cause related to drug testing in this case, so we're in that as well. So, Mr. Malero, where do we stand with Mr. Garrow's cases today?
Judge, trying to read Mr. Glazer's handwritten notes. It says set for trial. Mr. is to the contempt or show cause. Mr. Garrow does have some medical records. It looks like we need to review. So I'd ask to set that out as well.
Well, my concern on the show cause is that he's not doing his drug testing.
Apparently he was in the hospital or something, Judge. Do I have a? Is it judges that he missed some tests or is he testing positive?
He didn't appear on 4 occasions and didn't give a sample on August 28th.
He briefly referenced having been in the hospital, but he has the records with him. I haven't looked at them yet. Would the court permit him to come to my office so I could review those? And call and put this out for a couple minutes?
Yeah, I'll do that. So, Mr. Garrow, you're gonna have to go, do you know where the public defender's office is?
Yes.
Right, you need to go there right now
Okay.
and take whatever documents you have to Mr. Malero.
Okay, well, on the 28th, I had to spell that,
All right, I don't want you to
Okay.
say anything right now, okay? You need to talk to Mr. Malero first.
Okay, Richard, you're to continue with the drug screening, so make sure you're calling in every day. So if you're not in
I
the
ain't
hospital,
calling.
you're expected to be there.
I didn't call today because I didn't get out of work till 7:30 this morning.
Okay, so Mr. Garrow, that's not a reason
What's it called?
to not call.
Oh, I know, I just came from court, I came here. From work, I came over here because I was running late. I work Taco Bell, I work 36 for maintenance.
You need to start participating in your drug testing.
I can do that. Go too far up over there.
Go to Mr. Malero's office. Mr. Malero, while we're waiting on that, you need to speak to Mr. May.
Yeah, I suppose so. Thank you, Judge.
Okay, Mr. Murphy.
Can I just also, could we have Willie Morin in front of the judge, please? Willie. Got it. Thank you. Bye.
Mr. Amadeo, what case are you here for?
Miss Brent Pinkleman, Your Honor.
Okay. Are you gonna need to speak to him?
No, Judge, I'm not. Thank you.
All right, this is file 25-22212-FH, People versus Brent Stephen Pinkleman. We are here today for a pretrial conference in the case, and we're proceeding today by video conference. First, can you have the attorneys place their appearance on record, beginning with Ms. Wise?
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Brent Pinkleman. We both consent and thank you for allowing the Zoom. Brent, please state your name for the court.
Brent Pinkleman.
All right, and Mr. Amadeo, where do we stand with Mr. Pinkleman's case today?
Your Honor, last time we were here, we were talking about a potential trial out in May based on Prosecutor Wise's and my schedule that was acceptable to the court. The reason for that delay is because Prosecutor Wise has the Warner case, which is going to clog up some things. And I've got a ton of cases between now and then. The client is not in custody and has waived all statutory timeframes. If that works for the court, I'd just like to get a date out that far if possible and get a scheduling order if allowed.
All right, Ms. Wise, is there anything you need to address from people's side?
No, Your Honor, that is accurate. I believe Mr. Amadeo's got a busy trial schedule until the Warner trial, and then obviously the court's clogged up with that, so anytime in May would be fine.
All right, how many days do you think we'll need for a trial?
I think 2 is sufficient.
Yeah, I would agree with 2.
Okay, Ms. Clark, could we have a 2-day jury trial date in May of next year?
May 27th at 10:30 and May 28th at 9.
Okay. That works for the defense.
Perfect.
Thank you.
Yes, that works for us.
Okay, so let's set a final pretrial then for let's go with May 13th at 8:15. All right, so the court will issue a scheduling order for that. Is there anything else we need to address today?
No, thank you, Your Honor.
Okay, all right then, Mr. Pinkleman, you're all set. You can log out.
Thank you, Your Honor.
Thanks, Judge.
Ms. Underwood, do you need to speak to Mr. Morin?
Yes, sir, I'm here.
Ms. Underwood, are you there?
Yes, I'm sorry, Your Honor. Yes, I do need to speak to Mr. Morin.
Second. Mr. Valero, are you ready to proceed with Mr. May?
I am, Your Honor.
All right, we are on the record in files 25-22194-FH and 25-22216-FH, People versus Matthew Ryan May. We are here today for a pretrial conference in both of those files, proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Matthew May.
Okay, and where do we stand with Mr. May's cases today, Mr. Moore?
Your Honor, I would ask the court to set the matter for a jury trial. And then also going to ask to set up a bench conference in the next few weeks. to see if we can get it resolved short of trial. That'd be my request, Judge.
Okay, and how many days do we need for a trial?
I think on the uttering and publishing case, maybe 1 day and a half.
Yeah, that's probably right. Day and a half, 2 days.
Okay, so, Ms. Clark, can we have a 2-day jury trial date for Mr. May, please?
Thursday, October 30th at 9 and Friday, October 31st at 9.
Judge, probably gonna have to go past the second week of November. Cause I'm in a 2-week trial. The third day of November for 2 weeks.
Tuesday, December 2nd at 9 and Wednesday, December 3rd at 10:30.
Yeah, that's fine.
That's good for the people.
Okay, so December 2nd and 3rd, let's do a final pretrial on. It's gonna have to be November 19th.
That's fine, Judge. Those are fine.
Court will issue a scheduling order with those dates in it, and then if you want Mr. Malero to have a bench conference, just contact Francis and we'll get that on the schedule.
Absolutely, Judge. Thank you.
So I think we're all set then in this case. Mr. May, you can let the officers with you know that you're done with court.
All right, thank you.
Thank you, Judge.
Okay, home for Bradley Roarbach next. Okay, Ms. Underwood, are you ready to proceed with Mr. Morin?
Yes.
Okay, this file 25-22367-FH, People versus Willie Hopkins Morin. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Nope, that's mine. This one's mine. Sarah Brenner for the people on this one, Judge.
I apologize. Thank you, Ms. Brenner. Ms. Underwood.
Rhonda Underwood for Mr. Morin this morning, Your Honor.
All right, and where do we stand with Mr. Morin's case today?
Your Honor, just briefly, Mr. Morin is charged with 3 counts of failure to pay child support. The Attorney General's office has offered to have Mr. Morin plead to 1 count, Your Honor. And they would take no position as to Mr. Morin's release at sentencing to get a job and make payments, Your Honor. Mr. Morin has been in jail since this case was brought. I'm in the position today of Mr. Morin has no felony record, Your Honor. I'm in the position today to ask if perhaps the court would allow a COBS to that release at the point of sentencing for Mr. Morin to get a job and begin to make payments on his probation, Your Honor.
All right, Ms. Brenner, anything you want to add?
Your Honor, the agreement was to plead count 1, dismiss count 2 and 3 with an agreement to probation at sentence, and the jail time is to the discretion of the court. So I'll leave it to your discretion, Your Honor.
All right.
Thank you.
Okay, so with the understanding that Mr. Morin doesn't have any prior felony record and that he'd be pleading to one count of failing to pay child support, I do think that a probation sentence without an upfront jail sentence would be appropriate. So I would think that releasing him at sentencing.
Thank you, Your Honor. Then Mr. Morin will accept the offer of the Attorney General's office.
Okay, Mr. Morin, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes.
And I would just note, I do have a signed advice of rights form in the file from Mr. Morin. You are Willie Hopkins Morin.
Yes, sir.
And Mr. Morin, have you heard the statement of your attorney and the prosecuting attorney? Is it your intention to plead guilty today to count one, failing to pay child support?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, sir.
Other than as we've discussed on the record today, neither prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence. Is that correct, Ms. Brenner?
That's correct, Your Honor.
Ms. Underwood?
That's correct.
Is that also your understanding, Mr. Morin?
Yes.
The guilty plea is accepted. There'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Morin, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, sir.
Do you understand that you're giving those up?
Yes, sir.
How do you wish to plead to the charge that on or about April 1st, 2021 through July 31st, 2020, in the city of Adrian, County of Lenawee, state of Michigan, you did commit the offense of failing to pay child support?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Morin to plead guilty?
No, Your Honor.
None, Your Honor.
Mr. Morin, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes.
Ms. Underwood, would you like to establish the factual basis?
Yes, Your Honor. 1 second. Mr. Morin?
Yeah.
I take you back to April 1st, 2021 and to July 31st, 2021. At that time, did you have a child support order in Lenawee County Circuit Court, State of Michigan, Adrian, Michigan, City of Adrian, State of Michigan, County of Lenawee, Circuit Court number 21404-003 2DP? Did you have a child support order in that file?
As far as I know, yes.
And during that period of time, did you fail to pay the amount owed?
As far as I'm concerned, yes, I did.
Okay.
I don't know if it was
I
between jobs or not.
I believe the factual basis is established, Your Honor.
People are satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
It has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Morin has had full knowledge of his rights. He's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've addressed on the record here this morning. I will refer this matter to the probation department and set sentencing for October 16th at 8:15 a.m.
Thank you, Your Honor.
Mr. Morin, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
All right.
Your Honor, could I just have a brief breakout with Mr. Morin for just a second?
Yes. Mr. Malero, do you need a breakout session with Mr. Roarbach?
Probably, Judge. I'm going through this stuff from Mr. Garrow at the moment.
Oh, okay. Just let me know when you're ready then.
All right, thank you, Judge.
Mr. Fry, are you ready to proceed with Mr. Edwards?
I am, Your Honor. I know I just texted Mr. McCready. I'm not sure if he's on there
He
yet.
just popped up. Okay, this is file 25-22177-FH. People versus Earl Edwards, that's set for a pretrial, as well as pending contempts, or one pending contempt for failure to appear. Also file 25-22178-FH, that is set for a pretrial. First, we have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people. Good morning, Your Honor. Brian Fry, appearing for Edward Edwards.
Okay, and where do we stand with Mr. Edwards' cases today, Mr. Fry?
So, Your Honor, I know last time we were here, the court had approved Mr. Edwards to be released to a inpatient drug rehabilitation program. I hadn't heard from him, so I'm not sure if that's where he is. I know I did hear from him once and he was at the hospital. But I know I heard from Mr. Coast and Mr. Coast hadn't been getting updates, so I'm not really sure what's going on with that. I know we have I think a trial coming up in a couple months, I think, on this case, but I have not had a chance to really talk to Mr. Edwards, but it's good to see him on there.
And Judge, part of the bond conditions was he used to be released from jail to where he could go to treatment. But upon successful completion of that treatment, he was still required to report back to jail. So he did report to Salvation Army Harbor Light as directed, but then he left pretty quickly because of medical issues. I asked for hospital documentation to prove that he was there. I failed to get that. I've tried several times reaching him by phone. He does not answer. And I did check with the jail and he failed to report back to the Lenawee County Jail as directed. So at this time, I don't know his whereabouts.
All right, Mr. Edwards, where are you right now? Your device is muted.
The lady at the ProMedica, she says she sent Mr. Cosa over his fax and I still have that paperwork. Right now I'm at a rehabilitation / social house at Adrian Spring Creek because I had surgery and I needed rehabilitation for walking, and then I have a PIC line. I take liquid IVs. I can't take the pills aren't strong enough, so I take liquid IV. Take that 3
Okay,
times.
the question I asked is where are you right now?
Spring Creek. It's a nursing home here in Lenawee County. This is where the hospital placed me at.
Okay, what is the name of it?
Spring Creek. It's on Sand Creek Highway.
Sure. Okay, so you need to, Mr. Edwards, sign a release with that nursing home to allow them to speak to Mr. Coast.
Okay.
And that is Spring Creek, SPRING Creek Rehabilitation.
Yes, sir. Yes, sir.
Judge, could we ask that be done by a date certain?
The release, that needs to be signed today.
Thank you.
All right, and then we have a final pretrial set, it looks like for October 1st.
Yeah, we have a trial October 9th and 10th, and the people are ready.
Your Honor,
What is it, Mr. Edwards?
I've been in contact with Harbor Light. They know after this, they knew I wanted to come back. Is it okay if I still go back to Harbor Light for rehab? They're the ones that sent me off to the hospital because of they couldn't treat my my injuries, I should say, and the hospital kept me from there. Like I've been in the hospital and in here for like probably 4, 5, 6 weeks. I had surgery like 2.5 weeks ago, 3 weeks ago.
Yes, if you can get back into Harbor Light when you're released from the nursing home, you can go back to Harbor Light and complete the rehab.
Okay, thank you.
All right, Mr. Fry, anything else we need to address from your perspective today?
I guess, Your Honor, I would consider requesting that the trial be pushed out a little bit with Mr. Edwards. Sounds like his medical issues, and then, you know, his need for drug rehabilitation. I mean, I think he would still be in that program in a month for when the trial is currently scheduled for, and I don't know if I haven't heard from him, so I wasn't aware, you know, where he is right now, but haven't also been able to really prepare for the trial, and it sounds like I might not be able to with his current condition.
Well, I don't know if that's the case or not the case. What I will say is I don't have an objection to him going to rehab. I'm also not going to move the trial date for that reason. So you know where he is now. There's a month between now and the trial. I'd like you to contact him if truly he can't participate in preparation between now and then. I'll be willing to consider moving the trial, but I'm not ready to do that at this point.
I'll gather some more information on his medical condition, Your Honor. Mr. Edwards, you need to give me a call, give me your current number so we can talk and meet, okay?
All right.
Thank you.
Yeah.
All right, so we're all set. There is, as I said, a final pretrial set for October 1st. Mr. Fry, if you need to address something before that, you're welcome to contact.
Thank you.
Okay, Mr. Edwards, you can go ahead and log out.
Thank you.
Okay, Ms. Underwood, are you going to need to speak to Bianca McClenny Vidales?
I don't believe so.
Mr. Morin, you're done with court. You can let the officers know that you're finished for today.
All right.
Okay, good morning, Ms. Brooks. Can you hear me?
Yes,
And you are formerly Bianca McClenny Vidales, is that correct?
yes, and also formerly Brooks. I'm actually Clark.
Okay. All right, this is file 25-22160-FH, people versus Bianca McClenny Vidales, now known as Bianca Clark. We are here today for pretrial conference in this case, proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. Clark this morning, Your Honor.
And where do we stand with Ms. Clark's case today?
Your Honor, Ms. Clark, I believe lives in Kentucky. She is trying to provide proof of payment, but we've had some issues with that. So Ms. Brenner has made it very clear that we need proof of these payments and that they need to start showing up on the reflection in the website. I believe Ms. Brenner is okay with an adjournment at this point. I would say for 60 days. And in that time, we're going to get a situation where Ms. Clark can get these in a way that's acceptable to Ms. Brenner.
Yes, Your Honor. So I need to see $250 paid consistently each month, and then we can enter into the delayed sentence agreement that we've discussed. She's claimed she's made payments in the past. They've never showed up to the front of the court. So she does have a receipt that she made a payment yesterday. Hopefully that is legitimate and it goes to where it needs to go. So if I can see those payments coming to the front of the court consistently, then we can move forward. If the payments don't arrive the next time, I'm not going to agree to any further adjournments.
Can I say something?
You don't need
Am
to
I
say
allowed to?
anything.
Well, I just don't understand why it's not showing up. If it's showing up on my payment statement and I'm paying it directly to MISDU on the app and it's showing a confirmation, that doesn't show up in their system. And also all the payments that I've paid previously, the receipts that I've sent to your office, nothing is happening of that.
Nothing. But we're going to solve this, Ms. Clark.
I understand. I'm just getting frustrated because it's making it out like I'm not taking care of my end of the bargain, and I have been for years, and this isn't fair. And now I'm missing work because I'm having to keep showing up in court for things that I've already taken care of repeatedly.
I see a payment in May and I see a payment in July. I see
And I
two
also
payments
made
since
and I
bond was
made a
posted.
payment on Friday.
Right, and that takes a while to clear. So you can't do it the day before court and expect me to see it. It takes at least a week to clear the system so that it can come through. I'm sorry, Your Honor, that we're clogging your docket with this. But yes, I would agree to a 60-day adjournment.
And I would be happy to do the stip to adjourn, Your Honor, with Ms. Brenner's permission.
Yes.
All right, so 60 days, we'd be looking at November 5th at 8:15.
Thank you, Your Honor.
Thank you, Your Honor.
So, Ms. Clark, your next date is November 5th at 8:15 a.m.
Is it gonna be at 8:15? Because I just started my job and I can't keep taking off to miss. They're gonna let me go if I have to keep missing work.
I have a number of cases it's scheduled for that time. If you're logged in and I have everyone I need right at the beginning, I can try to call you right at the beginning, but I have, anywhere between 15 and 20 cases that I call each Wednesday morning.
Do I have to be present or can my attorney just represent me?
You have to be present.
Okay.
So you're all set, you can log out.
Thank you, Your Honor.
All right, so I have a person that I recently let into the meeting. It looks like you're a passenger in a car. Can you tell me your name?
I'm sorry, what was that?
Can you tell me your name?
Sabrina Bersiaga.
Okay, Ms. Bersiaga, we already addressed your case today. You can contact your attorney, Mr. Brandt, and he will get you updated.
Okay, thank you.
Okay, Ms. Underwood, I don't have Mr. Boss logged in today, and there's no one here in the courtroom. Do you know where he is?
I don't know, Your Honor. I was just in court with him last week. He may be confused about dates. I know for Ms. Brenner, he is paying. I know.
That's correct. He is paying.
All right, let me call it then. File 25-22189-FH People versus Trevor John Boss here today for a pretrial conference and proceeding by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Boss this morning.
And as we discussed off the record, Mr. Boss is not present today. Ms. Underwood, is there anything that you'd like to say about that?
Yes, Your Honor. Just briefly, Mr. Boss has another case, and I think he may have slipped a date, Your Honor. I would ask the court and Ms. Brenner if she would agree to an adjournment, and we can perhaps show cause it so that Mr. Boss doesn't get a bench warrant and doesn't get picked up and have to sit in jail and stop paying.
Your Honor, this time, since he has appeared in the past, I would not object to adjourning the pretrial because he is paying his child support as well. If he fails to appear in the future, then I may have a different stance.
All right. I will then adjourn the pretrial at this point. I will treat this as a first failure to appear. If he fails to appear again, I would also note, Ms. Underwood, if you speak to Mr. Boss, there are now 2 orders for fingerprints in the file, and we still don't have fingerprints. So Mr. Boss needs to be a little more diligent in taking care of his responsibilities with respect to this case.
Thank you. Thank you, Your Honor.
I will adjourn this then to October 15th at 8:15 a.m.
Thank you, Your Honor.
And Ms. Underwood, would you do that stipulation in order, please?
I will do that with Ms. Brenner's permission.
Yes, thank you, Rhonda.
All right. Mr. Malero, are you ready to proceed with Mr. Garrow?
Yes, Judge.
All right, so back on the record in file 25-22330-FH and 25-22331-FH. Mr. Malero, you've had an opportunity to meet with Mr. Garrow now and review some documentation. So what have you found?
So, Judge, it's clear Mr. Garrow has some, I would say, serious medical issues, but he did not. The medical records he has, which is quite a few, do not correspond with the dates Mr. Coasts. But I would suspect, I know he was at the hospital yesterday for his condition. So I would ask to perhaps set this out a little bit for him to find these records and get them to Mr. Glazer on the show cause. And I think he's been directed to make sure he tests today, which I've reminded him.
All right, so I mean, obviously I can't continue the situation of adjourning this out and having Mr. Garrow not test. And so Mr. Garrow, is he there in your office?
Yes, yeah, Judge.
Are you there, Mr. Malero? All right, so Mr. Garrow, you need to start participating in the drug testing with Mr. Coast. If you don't, if you miss additional tests, I'm going to direct Mr. Coast to issue a warrant, and we're going to have you taken back into custody because I cannot have you out if you're not testing.
Okay, I got a test today, so I'll be over there.
You know where to go, right? 3rd floor.
So, I'll set this out for a pretrial then on October 1st at 8:15.
And Sam, he's on color, so he's going to be testing over at the center.
Do you know where that is?
Yeah.
All right, he says he knows where it is. So go there, don't go to you?
Correct.
Okay. So go to the center and test. Okay, well, hold on.
Okay, anything else we need to address with the case today?
No, Your Honor.
No, thank you.
Mr. Blair, then you needed to speak to Mr. Blevens, if I recall correctly.
Roarbach, Judge.
Yeah, I'm sorry, I was looking at the wrong part of the screen, Mr. Roarbach.
Okay, you can go.
I'll get, use the pen real quick, put it down, box over.
Mr. Murphy, do you need to speak to Mr. Blevens?
I don't, Your Honor. We can proceed on the record when the court's ready.
Okay. Okay, this is file 25-22175-FH People versus Nicholas Montgomery Blevens. We are here today for pretrial conference. And we are proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy appearing back, Mr. Blevens.
And Mr. Murphy, where do we stand with Mr. Blevens' case today?
Your Honor, at this time, I'm going to ask if we could set a one-day jury trial on this matter. We do have, I communicated with your office, with your staff yesterday. There is a motion hearing scheduled for September 24th. I'm filing that motion today. So I'm just asking to set a one-day jury trial sometime after that motion hearing. Obviously, I mean, that's only 2 weeks away. But also because of my schedule, I think I probably wouldn't be able to do a trial, even a one-day jury trial, until sometime in December. I don't think it's a restriction, but that's just what I can see. But that's what I was asking for at this time, would just be to set a jury trial on this matter.
I have been like 3 times.
All right, I'm sorry, that was a one-day jury trial in December.
Yes, I don't know if Mr. Brainerd thinks it would take longer than one day, but I think that would be sufficient.
I think one day is sufficient, Your Honor. I would agree that a December date is appropriate. Mr. Murphy and I have a 2-week homicide trial at the beginning of November, so I think both of us will be busy prepping for that before December.
Okay, so Ms. Clark, could we have a one-day jury trial date in December, please?
Thursday, December 18th at 9 a.m. Backed up to a day 7 of 7 jury trial.
For that December 18th, I'm sorry.
Yes.
That would work for the defense. Thank you.
That works for the people as well.
So December 18th at 9 a.m. Final pretrial. December 10th at 8:15. And the court will issue a scheduling order with those dates. Is there anything else that we need to address for today?
No, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Okay, Mr. Blevens, you're all set. You can go ahead and log out.
Mr. Blevens, I'll give you a call later next week, okay?
Ms. Underwood, you need to speak to Mr. Wagner. No, she logged out. So Mr. Wagner, you're gonna have to wait till Ms. Underwood gets logged back in.
Okay.
Okay, Mr. Murphy, I don't have Mr. Morris here today. Have you had any communication with him?
I'll speak with him, Your Honor. I thought I called him and talked to him a few weeks ago, so I'm kind of confused, but just give me a few minutes if you please, Your Honor.
I do have Mr. West here if you need to break out with him.
Could I speak to Mr. West and then I'll try to call Mr. Morris?
Yeah.
Thank you.
Okay, Mr. West, I'm going to put you in a breakout session with Mr. Murphy.
Thank you.
Okay, Ms. Underwood, do you need to break out with Mr. Wakeman?
I don't believe I do, Your Honor.
All right. Let me do Mr. Roarbach first, and then I'll do Mr. Wakeman. Okay, so this file 25-22356-FH, 25-22357-FH, and 25-22358-FH. Bull versus Bradley Dale Roarbach. We are here today for pretrial conferences in each of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Salvatore Malero on behalf of Bradley Roarbach.
I should say there are also pending contempts in the 356 and 357 cases that came up from district court. So, Mr. Malero, where do we stand with Mr. Roarbach's cases today?
Judge, we're trying to get some things figured out. One of which Mr. Roarbach is expressed an interest in perhaps addressing a substance abuse issue. So I'd ask to adjourn this matter for one final pretrial.
All right, Mr. Bayoneto, anything we need to address from the people's side?
No, Your Honor.
Mr. Malerno,
Yeah.
I've been in here for 60 days, so they probably come up my probation from downstairs and not reporting. That's probably why I got them the warrants, I imagine.
You don't have warrants, Mr. Roarbach.
Oh, okay. Thank you. Thank you. Thank you. Thank you. All right.
You have allegations of contempt. That's it.
Oh, allegations. Okay. Thank you. I'm sorry. I'm sorry, guys.
All right, let's set it for October 1st at 8:15 then.
Your Honor, I'm not available that week. So could we go the following week?
Yeah, following week is October 8th.
That'll work.
So October 8th at 8:15.
Thank you, Judge.
Okay, Mr. Roarbach, you're all set. You can let them know that you're done with court for today.
Okay. Thank you. Thank you.
Okay, let's see.
I thought I signed out on anything. I'm sorry. I'm sorry. Okay.
This you can, I can sign out on there.
Oh, you just leave them.
Just
Are you done?
Yes, sir.
Then you're, you can sleep.
All right.
Okay, this is file 24-21951-FH People versus Marvin E. Wagner. We are here today for a hearing on a alleged probation violation. We're proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Wagner this morning, Your Honor. Thank you.
All right, and let's see, I have in the file, Ms. Underwood, an amended warrant that includes some new violations. Have you received a copy of that?
I don't believe I have, Your Honor. It may have come in yesterday late.
Okay.
But
send
what
a
I would
copy.
like to say, Your Honor, at this time, is that the genesis of this matter, the case is scheduled for a pretrial in district court on the 30th, Your Honor. I believe that we are not in a position where we can have Mr. Wagner make any statements regarding this matter until after that matter is resolved. Therefore, I would ask the court to continue the not guilty plea. In the meantime, I will review the amended warrant with my client. In addition, Your Honor, since this is going to be set out, I believe, till after the 30th, I believe it would be appropriate for the court to address bond for Mr. Dillard. Mr. Dillard, I believe, has a valid no contact. I believe he would abide by that. I believe we could have reporting to Mr. Coast. Mr. Dillard, I believe, lives in a trailer that he could take away from the address that this is located at, the alleged offense is located at, and he's prepared to do that. We would ask for a PR bond for Mr. Dillard in this matter, with whatever provisions the court feels comfortable.
Rhonda.
All right, so.
Mr. Wagner.
That's Mr. Wagner.
I apologize, Mr. Wagner. I apologize.
We were just in the other courtroom for Mr. Dillard, so.
And so if the district court hearing's on October 30th, we can set it for November 5th. That's the following Wednesday. Ms. Walsh, is there anything you'd like to say with respect to the request for bond?
I would ask to deny the bond given the situation. Again, the driving, the DWLS that he did receive, now the drinking, and the alleged, he was arrested for domestic violence. All of these cause great concern of mine. There was a PPO that was filed and approved for the victim in this case that did include all of the names that was provided in the updated warrant with the added conditions. That's my opinion. If he does get released, I would ask that he be placed on alcohol monitoring as well as a GPS with Mr. Coast. And he is not allowed back on that property. So I'm not sure how he would get things. Is that your camper, Mr. Wagner?
Yes, ma'am.
Okay. Does anybody else live in there?
No,
Nobody's lived in there with you?
no.
How long have you been living in there? I wasn't aware of that.
It's right next door to the house. I stay out there because there's no real room in the house for me.
Okay, so my question was, how long have you been living in there? I haven't.
Oh, sorry. I've been sleeping out there for a couple months.
Okay. So it's yours to move, correct?
Yes, ma'am.
Okay.
Where would you move it to, Mr. Wagner?
I've got a couple places in the county that I can go to, or I got another friend that's on 4400 Draper Road, which is just outside the county line, just north of Napoleon, which would be closer.
Okay.
What I'll do is grant a PR bond with a GPS tether with a restriction that Mr. Wagner not be within 5 miles of the the address where this is alleged to have occurred. Also require a scram unit. Mr. Wagner shall not use alcohol, marijuana, or any illegal controlled substance. Must report to Mr. Coast as directed, not have any contact with any of the people named in the amended probation violation allegations.
And Judge, is this, is he supposed to have the scram unit and the GPS on his leg prior to leaving the jail?
Yes.
Thank you.
Your Honor, just in terms of economy, are the scram unit and the tether charged separately, or is it the same thing?
They're two separate units, is my understanding. I would defer. I don't know how they're charged.
Would it be? Would it be possible to just, would testing be cheaper? I'm trying to.
Given the conviction in this case, the conduct that's been alleged to occur, and that he I mean, the allegation now is that he blew, what was it, a point?
231.
231. I'm not comfortable with testing. I want 24/7 monitoring of alcohol use.
Thank you, Your Honor.
All right, so Mr. Wagner, you can let the officers with you know that you're done with court.
So what's happening? I don't understand what's going on.
So you've got a bond, you can be released, but before you can get released, you have to be fitted with a scram unit, which is a device that monitors whether you're consuming alcohol, and a GPS tether, which tells us where you are.
Okay.
All right, and there's some other restrictions, so you're gonna have to contact Mr. Coast and he'll fill you in on all of that.
How do I contact Mr. Coast?
Judge, if I can have a quick breakout with him, I'll explain the process with him real quick.
Sure, yeah, we can do that.
Thank you.
1 second.
I do just want to make sure to put on the record that there is an active PPO in place, Mr. Wagner, so you cannot go to that property. I don't know how, I mean, I don't know how you get your belongings and all that with the PPO, but you cannot go there.
Can I have my boss, which is
I don't know how that works. I would suggest you probably call a law enforcement and ask how you get that stuff. I don't know.
Okay.
You can have a third person go there and pick your stuff up.
Okay.
But it has to be coordinated with Ms. Glenn, though.
Yes, I understand that.
Okay.
Okay. Thank you.
Your Honor, do we have a Montana Novak?
We do. He is not logged in and not here in person.
I have no information.
So we can call it, this is file 24-51863-PP. Ashley Carpenter versus Montana Novak. We are here today for a hearing on an alleged violation of a personal protection order. We're proceeding today by video conference. The courtroom is also open to the public. Ms. Underwood, would you like to, well, I guess let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for petitioner.
Rhonda Underwood for Mr. Novak, Your Honor.
And record should reflect Mr. Novak is not present today. He was, in this case, I think, arrested at the petitioner's residence. Court arraigned him, issued a PR bond, and set this hearing for today. Ms. Underwood, do you know anything about his whereabouts?
I do not, Your Honor.
Right. I am going to issue a bench warrant for his failing to appear. I'm going to set bond on the bench warrant in the amount of $10,000 cash or surety.
Thank you, Your Honor. I believe that concludes my docket with you this morning.
Okay, thank you, Ms. Underwood. Mr. Murphy, are you ready to proceed with Mr. West?
Yes, Your Honor. Thank you.
And before I do that, Mr. Malero, do you need to speak to Ms. Julia Iikenberg?
Yeah, I would, Judge. That'd be good.
Okay, so I will set that up. And call West.
And Judge, do you have anything on Tyler James? Perhaps maybe a Nolly, maybe?
I do not have anything in the file.
Okay, all right. Well, he's in my office.
Okay. All right, so let me put you in a breakout session with Ms. Julia Iikenberg. Okay, and so this is file 20-20069-FH and 25-22294-FH, People versus Wendell Charles West. Set for pretrials today. The 069 case also has 2 pending contempt of courts. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Mr. West.
And Mr. Murphy, where do we stand with Mr. West's cases today?
Your Honor, at this time, there is an offer by the people for Mr. West to plead to operating while intoxicated, third offense in both files, an agreement to not charge an absconding charge for the older file, the failure to appear on the older file. And there would be no agreement about sentencing. That would be purely left up to the court. At this point, Mr. West was asking to set a jury trial and for me to have a comment with the court and the people before that jury trial. So I guess on the older file, we're asking to set a one-day jury trial unless the people believe it would take longer than 1 day. I think given what I understand, maybe 1 day would be sufficient. So I'd ask for a one-day jury trial to be set in the matter, please.
Okay, Mr. Sneed, do you agree 1 day is sufficient on the 2020 case?
If we're going to set it for trial, then we're going to retract the offer to dismiss this habitual offender supplements. So I just want to make that clear. And yes, it would take 1 day.
Okay, Ms. Clark, can you give us a 1-day jury trial date?
Thursday, December 4th at 9 a.m.
That works for the people.
That works for the defense.
So December 4th at 9 a.m. and let's do a final pretrial on November 19th at 8:15. Court will issue scheduling orders with those dates. We'll set the 25 case, the newer case, for a pretrial on the same November 19th date. Anything else we need to address in those cases?
Nothing further from the defense. Thank you.
No, thanks.
Okay, so Mr. West, you are all set. You can go ahead and log out.
That November 18th.
November 19th.
All right.
At 8:15.
All right. I got it.
Okay.
Thank you.
Thank you.
Thank you, Mr. West. I'll be in touch.
All right. Thanks.
And Mr. Murphy, any luck contacting Mr. Morris?
Unfortunately not, Your Honor. I left a message on the phone number that we have, but I haven't received a phone call back.
All right.
And Judge, for Mr. Morris, we actually have a warrant for him for not testing. He's missed 8 consecutive tests. We even offer him to do testing at a reduced rate of only $5 a test. He has yet to make 1 test.
So I do see that warrant. It was entered August 4th. Okay, so this is file 25-22334-FH People versus Robert Scott Morris Sr. We are here today for a pretrial conference in the case proceeding today by video conference. The court is also open to the public. And I first have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy appearing by Mr. Morris.
And Mr. Morris is not present here in the courtroom today. He's not logged into the Zoom session, and he has not been at any point this morning. Mr. Murphy, is there anything you'd like to say about Mr. Morris?
Your Honor, I tried to call Mr. Morris this morning on the phone number that we have on file, and I left a message, but we haven't received a phone call back from him, so I apologize, but there's no more information to give the court.
Point, Mr. Morris has failed to appear. I would note there is also a bench warrant that was issued on July 31st by this court for Mr. Morris's failing to participate in drug testing. He's now failed to appear here this morning. Going to issue a bench warrant for the failure to appear. I will set bond on that bench warrant in the amount of $25,000 cash or assured.
Understood, Your Honor. Thank you.
Okay, Mr. Amlero, are you ready to proceed with Ms. Juilliard Iikenberg?
I am, Your Honor.
Okay, so this is file 25-22141-FH People versus Melissa Juilliard Iikenberg. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Banner.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Ms. Juilliard, Your Honor, and my computer's telling me I no longer have a camera, so I'm sorry. So I broke the camera. Which,
okay,
I guess, figures.
Where do we stand with Ms. Juilliard's case today then?
Judge, We are still working to resolve this, and I think it can be, but I know the case is old, so if we could set it for probably a 2-day trial, that would be great. Anytime after the second week of November would be perfect.
Okay, Mr. Bandit, do you agree that 2 days is sufficient?
I do, Your Honor. I think there's been a misdemeanor offer that's been out there, I think, really since we were in district court. I would just add for the record that that offer likely will be withdrawn at the last pretrial, or at the final pretrial if it's not accepted.
Yeah, we'll figure it out. Don't get too worried, Mr. Bayonetto.
Okay, so a 2-day trial, I'm sorry, sometime after what date, Mr. Moore?
So Judge, I have a 2-week trial starting in the beginning of November. It's pretty extensive, so I'd ask that anytime after that, whatever, probably after the 20th or something.
Okay, Ms. Clark?
We could do Tuesday, January 13th at 9 and Wednesday, January 14th at 10:30.
That works for the people.
That's fine.
Okay, so let's do a final pretrial then on January 7th at 8:15. And court will issue a scheduling order. Is there anything else we need to address with this case?
No, Your Honor.
No, Judge, but if we get this in a position to work out, we'll come before you soon.
Okay, that sounds fine. Okay, so Ms. Julia Iikenberg, you can go ahead and log out. You're all set for today.
Thank you.
Thank you. Okay, Mr. Malero, have you had any communication from Mr. Clark?
Oh, yeah. That's not my case. Let me look, Judge. Maybe.
Wait.
I have not, Your Honor. And my defender database is not appearing. I love technology. That's Mr. Glazer's case, Your Honor. So essentially, yeah, I didn't really quite understand his note. I sent it to Mr. Sneed. I don't know if he understands it either. Did you
I'll
understand?
tell you what I
it?
understand.
The note that Mr. Glazer left for me?
Okay, let me call it then. This is file 24-22077-FH People State of Michigan versus Larry Clark. We are here today for a pretrial conference in the case. We are proceeding today. Actually, this is the final pretrial conference in this proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Larry Clark, filling in for John Glazer.
Okay. All right, so looking at the scheduling order that was issued in case it says the final pretrial was set for September 10th. But it was on the court docket today for September 2. I'm sorry, September 3. And that may explain why Mr. Clark is not present. Mr. Sneed, is there anything you would like to address at the moment?
Well, Your Honor, I guess I would first like to inquire if Mr. Clark had received notice for today's pretrial conference.
So the original, the original scheduling order that went out with the trial dates in it had September 10th. On July 8th, there was a notice of hearing that went out that set it for today at 8:15 a.m. There was a proof or a certificate of mailing indicating that that was sent to Mr. Clark at the address that the court has for him. So it would appear that he has notice. Mr. Malero, what were you going to say?
So my Defender database finally came back on again. The last entries from July, and it just says that it notes that he came into the office. Trial dates are the 16th and 17th with a final pretrial on the 10th. And he had a VOP that got dismissed. Hello?
Yeah.
All right. Because it now says that I'm on Zoom, but I am on Zoom.
I'm pretty sure you have been for a while now.
This is so crazy. Well, at least you can hear me. That's what the note says on the database. I don't know what the heck's going on with the Zoom thing.
Your Honor, if I could
think
make...
IT's mad at me again, Judge.
Yeah, I'm sorry, Mr. Sneed.
Your Honor, I would just propose, I mean, this is a possession of meth case based upon a traffic stop. The defendant's a habitual fourth offender. My notes indicate back in May that Mr. Glazer was going to, potentially have this matter resolved through a plea offer, which is an attempt with no upfront jail. So at this point, perhaps we could continue with a final pretrial on the 10th if Mr. Glazer is back and could speak to his client prior to a pretrial conference being held. Potentially we could resolve it, not have the necessity to have what's scheduled as a 2-day trial on this case.
Okay. That will have to be, I'm not here next week, which is why that date got moved.
Understood.
But I can talk to Judge Anzalone and see if she can handle that for me next week, or yeah. So yeah, go ahead.
I was just saying, alternatively, I would be fine vacating the trial set for the 16th and 17th and potentially just having a pretrial set out sometime after that date.
I would be, I think, okay with that also. I guess let's do this. Let me check with Judge Anzalone and see if she can cover that for me next Wednesday. And if she can, we'll leave it there. If not, we'll set it for the following week or something like that.
Okay.
And we will let you know what happens there.
All right, thank you.
What are we doing, Judge?
We're gonna leave the pretrial on for next week, but it will be before Judge Anzalone, unless we contact you and notify you otherwise.
Okay, thank you. This is so odd. So
Judge, I did
weird.
confirm that Judge Anzalone is available next week.
Oh, great, thank you. So, we'll leave it on for next week, but with Judge Anzalone instead of me.
So Judge, are we leaving the trial on for the 16th?
As of now, yes, I want to see
Okay.
what happens.
Thank you.
Okay, so Mr. Valero, did you say you had Mr. James in your office?
Yes, I'm looking at him, Judge. You'll have to trust me on this because I'm just happy I can hear you.
Yeah, I'm not, because your camera doesn't work.
Yeah, sorry.
Okay, so this is file 25-22329-FH, People versus Tyler Paul James. We are here today for a pretrial conference in this case, proceeding by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Tyler James. Mr. James, could you please identify yourself?
Tyler James.
Okay. And Mr. Malero, I believe you said something about a nollie process, but I don't have anything in the file at this point. So where are we with this case? Oh, Mr. Malero has disappeared now. We'll give him a minute to see if he gets logged back in. Oh, it's just a short question. Okay. Okay, we have Mr. Malero back now and we can see him.
It's a miracle. Hey, all right, sorry, Judge.
I'm not,
Mr.
I'm
James.
not sure. Okay, I'm not sure where you cut out, but I just said that you had mentioned something about a nollie process, and I don't have that. So where are things with this case?
No, Judge, I'd asked to adjourn it. The basis is Ms. Arnold and I had discussions. She requested some records from Mr. James. We did email those to her late yesterday. So I imagine it's just her waiting for her to make that decision. So I'd ask to adjourn it for that to happen.
Okay, Mr. Sneed, is there anything we need to address from the people's side?
No objection to that request, Your Honor.
Okay, let's adjourn it then to let's go with October 1st at 8:15.
Can we do the 8th, Judge?
Oh, yeah, it's the second time I've done that. The 8th is fine, yeah.
Great, perfect. Thank you for indulging.
Okay, and would you do that stipulation in order, please?
Yes, I will, Your Honor.
Okay. All right, if there's nothing else we need to address on that case, then I think we're all set.
We are good, Judge. Thank you for your patience with my computer.
No problem. We don't get a choice with those.
True. All right.
Have a nice day.
Yep, thank you, Judge. So we're done. I can go.
Yeah, the last one I have doesn't need a defense attorney because it's just a show cause and they aren't here.
Excellent. All right. Thank you, Judge. Have a good day.
Thank you, you too. Okay, so this is file 25-22309-FH, People versus Betty Nicole Sanchez. Today's date set for a hearing on an order to show cause related to allegations that Ms. Sanchez is not participating in her drug testing. Record should reflect that an order to show cause was issued directing Ms. Sanchez to appear today at 8:15 a.m. It is now 11:05 a.m. Ms. Sanchez has not appeared at any point this morning, either by logging into Zoom or by coming to the courthouse in person. I am going to issue a bench warrant for the failure to appear. I will set bond on that bench warrant in the amount of $50,000 cash assured.
Thank you, Judge.
Thank you. Okay, I think that is everything on the documents.